All right, strap in, because this courtroom moment is anything but ordinary. From the second the hearing begins, it's clear we've entered the sovereign citizen twilight zone. The defendant's spouting off buzzwords like he's casting legal spells, tossing around jargon that makes no real sense, and trying to hijack the entire process before it even gets rolling. But here's the twist. The judge is having none of it. No patience, no pandering. You can practically hear the gavel thunder through the screen as she shuts it down. What we're witnessing isn't just a legal proceeding, it's a masterclass in courtroom control. Let's dive into this legal chaos and watch the judge put the brakes on the nonsense.
What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you are wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You are what?
The attorney of fact.
Wait a minute. Attorney of fact? Yeah, that's not how any of this works in a criminal courtroom. Unless you're wielding an actual legitimate power of attorney, and even then, that's more of a civil court move. You can't just roll up and start talking for someone else. This isn't a high school debate club. If you're not the defendant or a licensed attorney, you've got no business speaking. So when this guy tries to pull that off, you already know the train is about to leave the rails. Judges, do not entertain legal fantasy roleplay. Buckle up, because this is about to go sideways in record time.
What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court.
And boom, there it is. The judge drops the hammer and makes it crystal clear: no power of attorney, no voice in this courtroom. This isn't some community board meeting where anyone with a paper can speak. It's a criminal court, and the rules are firm. Either you're the defendant or you're a lawyer with a bar card. There's no sovereign loophole, no secret handshake, no workaround. The judge doesn't just shut it down. She slams the door shut and bolts it. This right here is a textbook example of courtroom authority in action. Let's keep going and watch how fast the rest of this collapses.
All right, this is in the state of Tennessee, Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel.
Now we get to the paperwork, and oh wow, it's a sovereign citizen greatest hits collection. It's got everything: archaic legal phrases, dusty case law from the 1800s, and a bunch of random demands that have absolutely zero standing in a criminal courtroom. Honestly, it reads like it was copied from a fringe internet forum about maritime law and gold-fringed flags. Who told these folks that quoting a canal company case from 1832 was going to stop a modern judge? Spoiler alert, it won't. All it does is make them look wildly unprepared and completely unserious. Let's see how quickly this fantasy filing gets shredded.
Time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee.
And here comes the moment of reckoning. The judge doesn't just reject the filing, she calls it out for what it is: pure, unfiltered legal nonsense. This is where the rubber meets the road. You can't just sprinkle a few Latin phrases on a document, wrap it in outdated legal jargon, and expect the criminal justice system to bow to your imaginary rules. Courts run on facts, laws, and actual precedent, not wishful thinking or sovereign daydreams. This isn't Hogwarts, and Latin isn't a spell book. The judge knows it, the lawyers know it, and somewhere deep down, even this defendant knows it. This is the point where fantasy hits the wall of reality, and reality wins.
A jury certainly would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a possibility? If you put a notice up there for tonight, if they really read your mind, that we need you on February the is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry,
July 15th.
July 15th. All right, to Matthew Aldridge and the individual standing before me whose name must not be altered, uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th.